Illinois Real Estate License Law Questions. Question 1. A candidate is planning the broker exam schedule and wants to understand the Illinois specific portion. How is the state portion commonly structured in the current SCI bulletin during Alex's Belleville 2 flat building file review? Option A, 40 questions with 90 minutes allowed and a 75% passing score. Option B, 100 questions with 150 minutes allowed and a 70% passing score. Option C, 50 questions with 120 minutes allowed and a 74% passing score. Option D, 90 questions with 150 minutes allowed and a 75% passing score. The correct answer is option A, 40 questions with 90 minutes allowed and a 75% passing score. The Illinois broker exam has a separate state portion listed as 40 scored points, 90 minutes, and a 75% passing score. The 100- question 150- minute format describes the national broker portion. The 50- question 120- minute option reflects residential leasing, and the 90- question format applies to a different examination category. Question 2. Jordan prepares a price opinion for a seller in Oak Park to help set a listing price. Which limitation should be remembered? Option A. A CMA always creates a guaranteed sale price. Option B. A CMA or broker price opinion is not the same as a formal appraisal by a licensed appraiser. Option C. A broker price opinion transfers title. Option D. A CMA eliminates all disclosure duties. The correct answer is option B. A CMA or broker price opinion is not the same as a formal appraisal by a licensed appraiser. A CMA or BPO can help estimate market price for brokerage purposes, but it is not a formal appraisal. It does not guarantee a sale price, transfer title, or remove disclosure obligations. Question 3. A buyer purchases for $270,000, makes a 25% down payment, and has $5,300 in closing costs. About how much cash is needed at closing before credits? Option A, $67,500. Option B, $5,300. Option C, $72,800. Option D, $264,700. The correct answer is option C, $72,800. Cash needed combines the down payment and closing costs, 25% of $270,000 plus $5,300 equals $72,800. The other choices omit either the costs or the down payment, or subtract costs from the price incorrectly. Stressed about your Illinois real estate exam? We can take Illinois real estate exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. Drew passed the Illinois broker examination but delayed the license application for more than a year. What is the likely exam-related consequence? Option A. The score remains valid permanently. Option B. The candidate becomes licensed automatically. Option C. Only a name-change form is required. Option D. The passing examination result may no longer be usable for licensure. The correct answer is option D. The passing examination result may no longer be usable for licensure. The SCI bulletin states that candidates must apply for licensure within 1 year after passing the appropriate examination. A permanent score, automatic licensure, or a simple name-change form would not satisfy the application requirement after the score validity window has passed. Question 5. A landlord uses a consumer credit report to evaluate Drew's rental application. Which law commonly appears in property-management screening questions during Logan's Naperville mixed-use storefront file review? Option A, Fair Credit Reporting Act. Option B, Truth in Zoning Act. Option C, Statute of Frauds only. Option D, Uniform Commercial Code Bulk Sales Rules. The correct answer is option A, Fair Credit Reporting Act. Tenant screening that uses consumer credit information implicates the Fair Credit Reporting Act. The other choices do not specifically govern consumer reports used to evaluate rental applicants. Question 6. A rental property has NOI of $24,000 and a value estimate of $300,000. Approximately what capitalization rate is indicated during Kendall's Rockford vacant lot file review? Option A, 4%. Option B, 8%. Option C, 11%. Option D, 12.5%. The correct answer is option B, 8%. The capitalization rate is NOI divided by value, so $24,000 divided by $300,000 is about 8%. The other answers have the rate, add unsupported points, or invert the formula. Question 7. An owner personally advertises and negotiates the sale of the owner's own suburban ranch home. Why is this usually treated differently from brokerage for others? Option A. Every owner must hold a broker license before signing a deed. Option B. The owner is automatically sponsored by the buyer's broker. Option C. Owners may generally sell or lease their own property without acting as licensed brokers for the public. Option D. The owner may collect commissions from other sellers without a license. The correct answer is option C. Owners may generally sell or lease their own property without acting as licensed brokers for the public. Real estate license laws typically regulate brokerage services performed for others, especially for compensation. An owner selling the owner's own property is not thereby representing the public as a broker, while licensing would be required to collect commissions or broker transactions for other owners. Question 8. Jordan signs closing documents for an absent seller under a power of attorney. Which issue is most important? Option A. A power of attorney automatically makes the signer the owner. Option B. No written authority is ever needed. Option C. The broker may create authority by verbal approval alone. Option D. The authority must be valid and broad enough for the act being performed. The correct answer is option D. The authority must be valid and broad enough for the act being performed. A power of attorney gives authority only if it is valid and covers the act being performed. It does not transfer ownership to the signer by itself, and verbal approval alone is not a safe substitute for proper written authority. Are you looking for Illinois real estate exam actual questions? Visit our website pokerexams.com to access Illinois real estate exam study guide with actual questions and answers. Scan the QR code or click the link in the description to get Illinois real estate exam answer key today. Question 9. A buyer obtains a loan of $220,400 on a property appraised at $290,000. Approximately what is the loan minus to minus value ratio during Rowan's Joliet Suburban Ranch Home File Review? Option A, 76%. Option B, 24%. Option C, 86%. Option D, 61%. The correct answer is option A, 76%. Loan minus to minus value is calculated by dividing the loan amount by the appraised value, $220,400 divided by $290,000, or about 76%. The other percentages confuse equity with LTV or use an incorrect numerator or denominator. Question 10. Jamie posts a social media ad for a listing near normal using only a personal phone number and no brokerage identification. Which issue is most likely raised by Illinois advertising rules? Option A. A licensee may advertise without any broker identification online. Option B. Real estate advertising must identify the sponsoring brokerage in a compliant and not misleading way. Option C. Only print advertising must identify a broker. Option D. Brokerage identification is unnecessary if the property address appears. The correct answer is option B. Real estate advertising must identify the sponsoring brokerage in a compliant and not misleading way. Illinois advertising expectations focus on protecting the public from misleading ads and making the sponsoring brokerage clear. Online ads are still advertising, and the property address or a personal phone number does not replace proper broker identification. Question 11. A buyer and seller dispute whether a wall-mounted shelving stays with the property. Which test is most relevant during Casey's Evanston Farm parcel file review? Option A. Whether the buyer likes the item. Option B. Whether the item is expensive enough. Option C. whether the item has become a fixture based on attachment, adaptation, agreement, and intent. Option D, whether the broker wants it included. The correct answer is option C, whether the item has become a fixture based on attachment, adaptation, agreement, and intent. Fixture analysis looks at factors such as attachment, adaptation, agreement, and intent. Personal preference, price alone, or the broker's preference does not determine whether the item stays with the real estate. Question 12. A borrower pays 1 discount points on a $200,000 loan. How much do the points cost? Option A, $1,000. Option B, $3,000. Option C, a different result not supported by the facts 3. Option D, $2,000. The correct answer is option D, $2,000. 1 discount point equals 1% of the loan amount, so 1 points cost 1% of $200,000, or $2,000. The other figures use too few points, only 1 point, or add an unsupported amount. Question 13. A listing broker learns of a known foundation crack before a buyer submits an offer. How should the issue generally be treated in an Illinois exam scenario? Option A. A known material fact should be disclosed rather than concealed. Option B. It may be hidden if the seller requests silence. Option C. It is never relevant once the property is listed as minus is. Option D. It must be disclosed only after the buyer obtains a loan. The correct answer is option A. A known material fact should be disclosed rather than concealed. Known material facts can affect a buyer's decision and should not be concealed. A seller's request, and as minus is label, or the timing of financing does not eliminate the broker's duty to avoid misrepresentation and disclose material information. Question 14. A buyer reviews debits, credits, lender charges, preparations, and cash needed to close. Which document function is being tested during Riley's Elgin condominium unit file review? Option A. A zoning map amendment. Option B. Settlement or closing statement accounting. Option C. A subdivision plat approval. Option D. A deed covenant creating a life estate. The correct answer is option B. Settlement or closing statement accounting. Closing statements organize transaction charges, credits, preparations, and cash to close. Zoning approvals, plats, and deed covenants do not perform the same accounting function. Question 15. Annual property taxes are $3,600, and the seller owes the buyer a credit for 60 days using a 365-day year. Approximately how large is the credit during Avery's normal townhome file review? Option A, $300. Option B, $10. Option C, $592. Option D, $1,184. The correct answer is option C, $592. Daily preparation divides $3,600 by 365 and multiplies by 60 days, giving about $592. The other choices use 1 month, 1 day only, or double the required prorated period. Question 16. A residential seller in Illinois knows about past flooding but leaves the disclosure report blank. What concept is most directly tested during Cameron's Carbondale small apartment building file review? Option A. The buyer's duty to ignore all seller statements. Option B. The lender's exclusive duty to inspect the property. Option C. The appraiser's authority to waive statutory disclosures. Option D. The seller's disclosure obligations for known material defects. The correct answer is option D. The seller's disclosure obligations for known material defects. Illinois residential disclosure rules focus on the seller's disclosure of known material defects. Buyers still may inspect, but that does not make seller disclosure meaningless. Lenders and appraisers do not waive statutory disclosure duties. Question 17. A consumer asks why a state real estate recovery fund might exist. Which purpose is closest during Drew's Galesburg mixed-use storefront file review? Option A. Providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Option B. Guaranteeing every buyer a profit on resale. Option C. paying all ordinary home repairs after closing. Option D, replacing the need for broker licensing. The correct answer is option A, providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Recovery funds are designed as limited consumer minus protection remedies for qualifying misconduct minus related losses. They do not guarantee investment profit, pay routine repairs, or replace licensing and discipline systems. Question 18. Taylor receives $3,000 in earnest money and places it in a personal checking account for convenience. Which trust minus account problem is illustrated? Option A, a lawful automatic conversion of escrow funds into commission. Option B, commingling client funds with personal funds. Option C, a required method for handling every earnest money deposit. Option D, a title defect that is cured by recording a deed. The correct answer is option B, commingling client funds with personal funds. Client or customer funds such as earnest money must be handled through the appropriate special or trust account process. Putting the money into a personal checking account is commingling. It is not automatic commission, not the required method, and not a title minus recording issue. Stressed about your Illinois real estate exam? We can take Illinois real estate exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A buyer pays for the right, but not the obligation, to purchase a property at a set price during a stated period. Which agreement is described during Parker's Quincy rental duplex file review? Option A, open listing only. Option B, tax deed. Option C, option agreement. Option D, subordination agreement. The correct answer is option C, option agreement. An option gives the holder the right to buy under stated terms without requiring the holder to exercise it. An open listing is a brokerage agreement, a tax deed relates to tax enforcement, and subordination changes lien priority. Question 20. A sponsoring broker is asked to produce special account records during a regulatory review. Which practice best supports compliance during Reese's Waukegan Lakefront Cottage file review? Option A, deleting old deposit records once the closing occurs. Option B, keeping records only in the salesperson's personal email. Option C, combining all clients into one undocumented cash envelope. Option D, maintaining complete transaction and trust minus account records that can be examined when required. The correct answer is option D, maintaining complete transaction and trust minus account records that can be examined when required. Regulators may examine records to verify compliant handling of funds and transactions. Deleting records, relying only on a personal email, or using an undocumented cash envelope undermines record retention and auditability. Question 21. An ad states only a very low monthly payment without giving required credit terms or context. Which lending minus advertising law is often implicated during Alex's Belleville Suburban Ranch home file review? Option A, Truth in Lending Act and Regulation Z. Option B, Rule Against Perpetuities. Option C, Fair Credit Reporting Act only. Option D, Illinois Plat Act only. The correct answer is option A, Truth in Lending Act and Regulation Z. Regulation Z under the Truth in Lending Act governs many consumer credit advertising disclosures. The Rule Against Perpetuities and Plat laws do not govern loan advertising, and the FCRA focuses on consumer reports rather than payment minus ed trigger terms. Question 22. Rowan signs an exclusive listing agreement and later asks why the writing matters. Which answer best fits exam minus tested brokerage agreement principles? Option A. A brokerage agreement eliminates all disclosure duties. Option B. Written terms help define services, compensation, duration, and the parties' obligations. Option C. Oral promises always replace signed terms. Option D. A brokerage agreement transfers legal title to the broker. The correct answer is option B. Written terms help define services, compensation, duration, and the parties' obligations. Brokerage agreements define key business terms and help avoid disputes about services and compensation. They do not eliminate disclosure duties. Oral promises generally do not automatically replace signed terms, and the agreement does not convey title to the broker. Question 23. A seller receives an offer of $265,000 and responds with $268,000 plus a changed closing date. How should the seller's response be classified? Option A. A full acceptance of the buyer's original offer. Option B. A deed transferring title immediately. Option C. A counteroffer that rejects the original offer and proposes new terms. Option D. A lease option created by operation of law. The correct answer is option C. A counteroffer that rejects the original offer and proposes new terms. Changing material terms such as price or closing date creates a counteroffer rather than an acceptance. It does not transfer title, and it does not create a lease option unless the parties separately agree to those terms. Question 24. A sponsored licensee uses the team name River City Team in advertising. Which compliance concern should be checked first during Sydney's Peoria single-family home file review? Option A. Whether the team can operate without a sponsoring broker. Option B. Whether the team name creates automatic title insurance. Option C. Whether the team may set commission rates with competitors. Option D. Whether the team name and ad clearly avoid misleading consumers about the sponsoring brokerage. The correct answer is option D. Whether the team name and ad clearly avoid misleading consumers about the sponsoring brokerage. Team advertising must be clear enough that consumers are not misled about the brokerage relationship and sponsorship. A team does not replace the sponsoring broker, create title insurance, or justify antitrust violations. Question 25. Several liens are discovered before closing, including a recorded mortgage, unpaid property taxes, and a later judgment lien. Why is lien priority important during Logan's Naperville 2-flat building file review? Option A. Priority determines the order in which claims may be paid from the property's value. Option B. Priority decides who may advertise the property. Option C. Priority cancels the need for title insurance. Option D. Priority makes every lien disappear at listing. The correct answer is option A. Priority determines the order in which claims may be paid from the property's value. Lien priority affects the order of payment when property is sold or foreclosed. It does not control advertising rights, eliminate title insurance analysis, or erase liens merely because a property is listed.